Welcome to this episode of Post Grant Radio, brought to you by Fish & Richardson. This podcast is dedicated to discussing the latest news and developments in post-grant proceedings before the Patent Trial and Appeal Board. Host Rick Bisenius, an attorney at the Twin Cities office, talks with practitioners and thought leaders across the country discussing a wide range of post-grant topics.
Hello, this is Rick Bisenius. Welcome to another edition of the Fish & Richardson Post-Grant Radio podcast. Joining me today is patent litigator Nick Tsui from Alston and Bird. How you doing today, Nick?
Great. Thanks for having me, Rick.
I'm excited to have you on the show today. Nick and I worked on a series of cases several years back together that was a rather complex mix of a lot of different patents with related terminology, proceeding in several forums. There was a state district court case, there was an ITC proceeding, there were several IPR petitions that we'd filed, and there was a lot of complex issues that came with that. And so I wanted to have Nick on the show today to kind of discuss things that we learned from that process and how he's applied that to his practice going forward. So I'm very happy to have you here today. But before we jump into that, could you just briefly describe your practice for the listeners?
Yeah, sure. So I've been at Alston and Bird in the Atlanta office for about 7 or 8 years now, doing predominantly patent litigation. But I am an IP litigator, so it occasionally does involve trademarks, trade secrets, occasionally copyrights and Lanham Act claims and things like that when the patent work is part of a larger dispute that involves some other areas. But primarily it is patent litigation, and kind of similar to our experience together, oftentimes that involves district court, ITC, PTAB proceedings. And so we do a good mix, or I do a good mix of all of those. And probably pretty typically for a lot of people's practice is that the district court tends to be Eastern District of Texas, these days Western District of Texas, as the kind of the big venues that folks find themselves in. But it's pretty good scattering across the rest of the country. It's occasionally you get some other districts in there that just for fun to throw in some diversity. But the big ones tend to be the two Texas places.
Have you tried any cases in Delaware?
I have not. I've had a couple of cases that have started out there, but nothing that's gone all the way through to trial.
We're going to talk about the interplay when you've got a lot of different or multiple different proceedings going on. You've got a lot of patents. Some of them might be actually related. Some of them might just be related technology or related terminology. Just to start out, what would be one of your top concerns when you've got concurrent litigation or concurrent ITC proceeding while there's a PTAB proceeding going on?
Yeah, I mean, the biggest concern is going to be aligning the positions so that the kind of positions you're taking in the briefs before the PTAB are consistent with the positions that you're taking in front of the district or the ITC, district court judges. They don't have to follow the same, claim constructions or things that you've necessarily said in front of the PTAB. It's not binding, but it's going to be difficult to sort of unwind a position that you've taken in one forum and try to explain why you haven't taken that same position in another forum that certainly doesn't look good. And so you do want to be careful with that, because it's pretty typical that the ITC or district court litigation is enough work that it's going to be a different person who's probably writing the briefs and doing the arguments over on the PTAB side. In our case, it was different firms. So yeah. We for sure had a joint defense group where different folks were handling the briefing. And so you want to make sure that you're not going to take, or someone's not taking a position in front of the PTAB to preserve validity that ends up narrowing down the invention and what the claims ought to cover, to the point where now you start sacrificing the infringement positions over on the litigation side. If you're the plaintiff, if you're the defender, then it's just the reverse, right? You don't want to start saying that the invention covers all these things so that you can then show the prior art covers those too, and then it turns out now your non-infringement positions are gone because you've now admitted that it covers those things. And so it is hard to keep track of all the moving parts, especially if there are a lot of patents involved and a lot of folks involved. And so, in a perfect world, everyone's communicating well and reading all the briefs on both sides to the extent you can. If it's a big enough case and you've got the budget, you'd like to be able to have people involved on both sides, which is, I think we got lucky in our case that we were able to do that. But that's kind of where that's headed in terms of trying to make sure that you can keep all the positions consistent and as aligned as possible.
Yeah, I think there's a huge advantage when you have a client that understands that you need a good amount of communication between your litigation team and your IPR team, even if there are two different teams within the same firm. Some clients I could see getting upset. Oh, well, why are you guys having all these meetings? But keeping those terms consistent and keeping your interpretations consistent, even if you're not having express claim constructions for some of those terms in the PTAB proceeding, you want to make sure you're being consistent with the way you're construing them in the district court or in the ITC.
Yeah, it's exactly right, and there's a little bit of luck involved too in terms of the folks that you end up dealing with, especially if it's a different firm. In terms of hoping that you get along and that that communication is efficient. There are times when it's not. There are times when it works well. I think I think we got lucky with our firms and the case that we were on. I think our teams got along pretty well. We're able to communicate pretty effectively and efficiently. So I don't think that anybody had any problems and understood that communication was going to be critical for us to be successful.
Yeah, a little bit off topic, but yeah, speaking of, I think our teams did work together really well. And I've been in other situations where we've been working with litigation teams from other firms. And from what I've seen, I think it works best when the attorneys in both firms are really working together to do the best job for the client rather than trying to one up each other and show, oh, that other side, they're incompetent. You want to, maybe you want to give this entire case to us, or your next case, you want to give the entire case to our firm. And I think the client can tell when that's happening, and the best way to impress them is really just get the best result for the client, which I think is what happened in that case.
That's exactly right. I mean, and there are definitely other experiences that I've had where the other firms that we were working with did not go as smoothly as it did when you and I were working together. And I definitely think that it's an added headache for everyone when it becomes kind of a one-up competition between the firms and less about just winning the case.
Yeah.
I do think that you and I got a little lucky that we got along. We all saw the big picture and we were able to focus on the prize and it made everything go so much smoother.
Yeah. So what's an example of a footfall that you've seen happen when the teams aren't communicating well?
Yeah, I mean, so to the original point that we were discussing, I've seen flat out contradictory statements all the time. Yeah. Where that's one of the classic things that I love to do as a litigator is we'll pour over the PTAB briefing because more often than not, there are statements in there that are directly contradictory to what is being briefed over in the litigation side. Expert testimony is great there too, because the experts, again, very common that the expert will take a position that's just directly contradictory to what they're trying to take over in the district court or the ITC side. So we always mine the PTAB proceedings, looking for contradictory statements. Another, sort of more nuanced footfall is when there's many patents involved in the litigation and you're taking them one at a time over in the PTAB. Sometimes if it's the same subject matter, there may be overlapping prior art. And so one of the things that comes into play is that there may be questions asked about the prior art that really are directed towards a different patent that is in the litigation. And so what happens is your PTAB depositions and your PTAB proceedings end up becoming sort of a proxy war for really what's going on over in the litigation side. And so if people aren't paying attention, there could be all kinds of admissions or contradictory statements that you don't realize are even contradictory at the time because it doesn't seem like it's got anything to do with the one patent that IPR is about. And it may not. It may be completely setting up arguments for a different patent that's in the same general space. And so that's something that we've seen a couple that we saw it together in our case. Yeah. And so that definitely happens. And it's something that creates extra concerns that you have to deal with and prep your witness for and be worried about if you want to be successful on both fronts.
Yeah, I think one interesting way to leverage your arguments in the PTAB for an ITC or district court proceeding, especially a district court proceeding, one that might be taking a lot longer, that's not in Eastern or Western District of Texas, is to get the other side to take a claim construction position early in the PTAB that you can hold them to later, because they may not necessarily know your infringement or your non-infringement positions yet at that point in time, depending on the timing between the two proceedings. And if you have a good infringement or non-infringement argument, or maybe something could help with a 101 invalidity argument, you can get the other side to take a position on a particular term that they don't realize what your argument is going to be later in the district court, and then you can hold them to it.
Yeah, that's exactly right. It's making someone take a position before they're really ready to is exactly a really important strategy that does bring a twist to a PTAB proceeding that wouldn't be there if there wasn't a concurrent litigation going on.
Yeah. So just a few minutes ago, you mentioned really pouring through the expert deposition transcripts in the PTAB proceeding, and that raises an interesting question about the differences between depositions in a district court proceeding versus a PTAB proceeding. In the district court, it really is more of a fact-finding effort, whereas in the PTAB, that's the testimony that's going to the trial judges. So I was wondering if you could talk about some strategic differences in how you approach those two different types of depositions, and how that changes with respect to what type of concurrent proceedings, or maybe where the timing is in the two proceedings.
Yeah, I mean, so you're exactly right that if you've only got the PTAB proceeding going, the strategy is a little different, because that testimony that they give in that deposition is going to get in front of the judge. When you've got it on the district court or ITC side, that deposition testimony, other than for impeachment, isn't going to be what the evidence is. That expert's going to have to show up and actually testify on the stand, and that's what their testimony is going to be. And so the deposition is a lot less constrained. We're not afraid to ask questions about, exploring their opinions, fleshing it out a little better. It becomes more about boxing them in and pinning them down to saying something that they can't change later when they come to trial. And so if you get a bunch of litigators over on the IPR side, what you'll probably find is that it sort of morphs into that. And it won't follow the same kind of feeling or procedures it would if it was pure PTAB lawyers or attorneys that are used to doing proceedings in front of the IPR proceedings or PGR proceedings. And the depositions might get a little more aggressive. You might find that the litigators may not really know all the rules as well for PTAB depositions with objections and things like that. Yeah. It's a little bit more wild west when it comes to the litigation side, and the strategy, it can be that, and we do toe the line a little bit and realize that, okay, this is all going to go into evidence on the IPR side, but a lot of our strategy as a litigator will be, this is an early look. The expert may not have any idea what the ultimate infringement positions or non-infringement positions are going to be. There may be other prior art that's not in the IPR proceeding because you just have limited space over there, but we may have a bunch of other prior art that we're curious about over on the litigation side that we can try to set up by getting the expert to commit to a bunch of different positions. And because that is going to go in on the record, the expert may feel a need to actually commit to positions and not be so squirrely, because then the PTAB APJs are going to see that. And so that's definitely going to be something that you'll see that the litigators will try to do, is just ask questions that are a little bit more open-ended, a little bit more on the edges of what the expert report may have even covered, to try to get this expert to get pinned down on a position that they may not really be ready to take yet. But if we can get them to say one way or the other, what does this claim really include or not include, it's going to be hard for them to then turn away from that on the litigation side.
Mm-hmm. Yeah, that once again, that kind of gives an advantage if you can be in a slower paced district court and have time to let those depositions play out in the PTAB before you get to that phase of litigation. You say if you're in Northern District of California.
That's right. Even in the faster districts, it becomes impeachment evidence that you just bring it up right in trial. If they say something different now in front of the judge or in front of a jury, and you bring out, well, that's not what you told the PTAB during those proceedings, that could become a pretty powerful statement.
As long as you can memorize the entire 4-hour transcript and have it ready to go during the trial.
That's right.
On the flip side of that, are there differences in the way that you prepare an expert for a deposition, if it's a PTAB deposition versus a district court deposition?
Yeah, the district court depositions or ITC depositions tend to go longer. The stamina can be an issue. On the PTAB side, it is, like you said, typically like a 4-hour deposition. It could go a little longer, but there's not quite as much ground to cover. Whereas on the district court or ITC side, it's pretty typical that the depositions go the distance and go the full 7 on the record. And so that's almost double the time. And so that can be a pretty big difference in stamina for the witness to be able to take that. And so sometimes the depositions on the IPR side will start going longer than you'd think they would. You do want to prep the witness if you do know the issues that are going to come into play. If you don't know, then it becomes pretty important that they stick to their report, more so than it already is. But it may be something that you want to hammer a little more during the prep session, that here are the areas of your report where I think it's okay if you want to go a little off script, eat up some time and talk about these issues. But these other ones, you really got to stick to your report. And if it starts going off script, you got to listen to the objection that this is outside the scope of your report, and you really got to lock it down and not let them go off and take a position on that, because it starts to get into ground that might be giving up some things on the litigation side that you don't want to do. And so you do need to do a little extra prep for those kind of issues that you wouldn't otherwise have to do.
Yeah, you talked about the length difference, and I find that to usually be true, but I had a 6-hour PTAB deposition a couple of weeks ago.
Oh, man.
And, I actually had one a few years back that went 2 days. It was for 3 patents. We had the same expert for 3 different IPR petitions, but even then, I didn't expect it to go more than 6 hours, and we went probably 4 or 5 hours into the second day for that one. And that was kind of surprising. Man.
That's brutal. That's the worst, is when you've got your mind already thinking, 3-4 hours into it, I'm looking at the clock, and then it goes, every minute after that is excruciating. I always have to tell myself and tell the witness when we go in, you got to expect we're going to be here till 8, 9, 10 o'clock. Then if we get out early, it feels great.
Yeah. Then you go grab dinner and it's a celebration.
That's right.
Another issue when it comes to experts in these parallel proceedings, I was wondering if you could talk a little bit about factors that you might weigh when you're considering whether to use the same expert for both the litigation and the PTAB proceeding versus using different experts.
Yeah, a lot of clients want to use the same expert, right? Because they're cheaper, it's more efficient. You don't have multiple people reading the patents and learning all the issues again. And to some extent, there's a little bit less concern that the one expert is gonna contradict him or herself. If once they say one thing over in one forum, it's less likely they completely forget it and take a totally contradictory position later. And at least they can explain for themselves. If it appears like it's contradictory, they can kind of say, "Oh, what I meant when I said that over here was really this other thing." And so there are pros to using the same experts, but there are cons. There's just the amount of work that's involved with depositions and expert testimonies. The trial calendar and the IPR calendar might line up in such a way that it's just too much for one person to handle. And so you kind of have to gauge that a little bit on the expert themselves. How much work does this person have? How much time can they spend on it? How much can they stuff in their brain and remember, over here on the IPR side, we're talking about this stuff, but on the litigation, I need you to remember it's a different ballgame over here, and there are different issues at play. And so that's something that's got to be kept in mind. We also like to think about, the presentability of the expert. Over on the PTAB side, it's just all on the paper. And so
you're not trying to win anybody over.
Yeah, that's right.
Trying to win them over with facts, not with your charisma.
That's exactly right. And it's videotaped, but I don't think anybody ever really has watched the videos. Sometimes it's not videotaped because no one really watches them.
I'd say the majority of the depositions I've participated in for the PTAB have not been videotaped. Now they are, because we're doing them all over Zoom, and videotaping is just clicking a button instead of hiring an entire extra person with a camera rig. But yeah, even then the videos almost never, I've actually never seen a video get submitted as evidence. And so judges never see it.
Yeah. All they see is what's written down in the transcript. And that just doesn't see, the pauses or the mannerisms and whether or not this person's just their physical presence is credible or likable. And those factors just don't come into play. But if you're over on the litigation side, even with the remote, video deposition or video testimony for the hearings or for trial, it still comes across whether this person's actual cadence and the way they speak and the way that they hold themselves, it all shows up and the judge can see that and factors that into the credibility of the witness. The juries, certainly for live trials, they can see all that and they can see the interactions with the expert and they can see the judge's interactions with the expert. And that all plays very heavily into whether the jury is going to find this person credible. And then so it's a very different type of look when you're, interviewing the experts and deciding who do you want for the district court litigation or ITC litigation. You do have to find somebody who is likable and presentable. And whereas on the PTABs, you always like to have someone who's likable and presentable, but you can definitely pick up some experts on the PTAB side that you would not be able to do on the district court or ITC side.
Yeah, and I definitely agree with that point. Charisma is not as important or anywhere near as important on the PTAB side. One point that I don't think you brought up that I always kind of consider is how dense is the technology. And so, some patents are covering, technology that everybody's familiar with. It might be, covering a user interface on a cell phone or things that, somebody with like a cursory computer understanding would understand. And other times it's really dense, heavy electrical engineering or material science and things that are really complex. And in those situations, that's where I'm more likely to want to have different experts because I want my expert on the PTAB side to be somebody that is not just an expert in the general field, but an expert in whatever specific aspect of the technology we're talking about in that one patent.
Yeah, that's exactly right. And the board, as you say, they're more likely to dig in and get really down into the technology or understand it. They see these things all the time and this is their specialty, is what they do. And so they'll follow that expert down, a little bit of the rabbit hole and get down into the weeds and understand whether or not the arguments they're making work. Whereas, the sort of the polar end of the scale is, you're in a jury where, at this point now, what my expert's really trying to do is just boil this down to something real simple and real easy for the jury to believe or understand. And it's very different. They're not going to really want to go all the way down in the technical weeds and use the jargon. They're going to really want to bubble it up to kind of what lay terms can be understood. And so that's definitely a difference because some experts can do that and some experts really can't do that. And they really, once they think about it a certain way, they really can't explain it any differently than they'll say, well, this is the technically accurate way to do it. That's how I can describe it. And so teasing all that out when you're interviewing the experts, screening them in the beginning is definitely important to know whether this is the kind of expert that's going to be in front of a jury or this is the kind of person that's better suited to get in the weeds with the board.
Yeah, I totally agree. Well, I've exhausted all the questions I have for you. Do you want to make any more points on balancing PTAB and litigation, or should we move into the lightning round?
I think the lightning round sounds pretty exciting.
All right. These questions are just for fun. You can pass on any of them. There are no wrong answers. Well, there might be wrong answers. But all right, let's get into it. Question 1. So you're based in Atlanta. We talked about that at the beginning. It's home of the world champion Atlanta Braves. Who's the starting shortstop for the Braves this year?
I think it's going to have to be Dansby.
That's right. Yeah. That's one for one.
Oh, so yeah. So there was a right answer. Okay.
Yeah. Dansby. Yeah, you got it. Okay. Question 2. What's the holding of TC Heartland versus Kraft Foods? You can pass
Supreme Court.
What's that?
At the Supreme Court or at the other level?
Yeah, the Supreme Court. Supreme Court. Yeah.
I'm gonna botch the exact wording, I'm sure, but it was about the venue, not whether it was Oh my goodness, you're gonna make me feel terrible about this. But it was about how you qualify for the second prong of venue on where your corporation is domiciled. I don't know the exact word anymore. I can't remember. You're making me look terrible here, Rick. I can't remember.
Yeah, they tightened it. It couldn't just be acts of infringement. Now you had to have an actual established place of business.
That's right. Established place of business.
No, you got it though. It's the venue case. All right. Question 3. You did your graduate work just outside of Boston at a school that is well known for their pranks, which the students refer to as hacks. I'm wondering, either can you name one of the hacks from 2007 when you obtained your PhD, or can you name one of your favorite hacks that we're talking about MIT for those that didn't catch my allusion before.
I think one of my favorite hacks was they actually televised this one for, I think it was some kind of version of Myth. I don't know if it was actually Mythbusters or it was some version of Mythbusters, but they were talking about crop circles. And could you really make a crop circle in one night that had all the aspects, the kind of the weird, there was some weird electromagnetic readings that have to come out of the pattern that you do, and then you have to go and make the whole crop circle with like a wooden board, and and you can't do it with any automated tools. And so they had some team of like 3 undergrads set out, and they're like, yeah, we can do this and get it all done in one night. And so they made a crop circle in the shape of one of the MIT buildings in like a cornfield. And it worked. They did it, and they videotaped it, and they showed how the whole thing could be done manually. How they even created the electromagnetic readings that someone later would come and get. I think they just pumped like they built like basically a portable microwave emitter, and then just pumped the ground with it. I don't know if that was environmentally sound, but they did it.
That's crazy.
So the guy, whoever the Mythbuster-ish guy, came and did all the readings and it was like, yeah, these checks all the boxes, and then for whatever they were doing, I think it was like, maybe it was even for a class, but I think it was a professor involved, and he was like, yeah, no, that was great, I'd give you a B as your grade. I was like, a B? I thought that was pretty amazing. They checked all the boxes, and at the end of the day, he said he was going to give him a B.
Man, harsh grading curve at MIT.
Yeah, that was pretty harsh, but I did like the whole alien crop circle thing. That was one of my favorites.
I'm going to have to look that up. Okay, sticking with your New England ties, where's the best place to get a lobster roll?
Oh, man. Well, so in Boston itself, the Union Oyster House is kind of the famous spot. And it's supposed to be, I think it's supposed to be the oldest restaurant in Boston. It's right in the real touristy area of the city. And I think all the celebrities go there. They've got like this big wall of like, Ben Affleck and Jennifer Lopez were here on such and such date. And so I always, if I'm bringing people who have not been in the city, that's always a place where I make sure we stop by and hit that at least once so that people can say they've done it.
All right, I'm going to have to check that out the next time we're there. Fish and Richardson's like lead office or main office is in Boston, so I go there occasionally to lead training exercises and things like that. I'll have to remember the oyster bar.
Yeah, you gotta do that. Union Oyster House.
Union Oyster House, got it.
I think it's either in Faneuil Hall or it's right there. So it's sort of and then you can go hit up Mike's Pastries afterwards if you've never done that.
All right, 2 more. Your firm is called Alston and Bird. My firm is called Fish and Richardson. So the question is, outside of fish and bird, what's the next best animal that should be included in a law firm name?
Oh, I don't know if anybody's got like one of the, the classic, like a tiger or a lion or something. You definitely don't want to go snake. That would be a mistake. But shark would be pretty cool. I think that would be a pretty good one. But animal names,
I was thinking narwhal. It's not quite as dangerous as a shark, but it's got that horn. It can be aggressive if it needs to be.
Yeah, let's go with that one. Let's say narwhal.
Tsui and Narwhal. I'm looking forward to that law firm.
All right, Bisenius, Sway, and Narwhal. We'll do it together.
There you go. All right, last question. This is a 112F interpretation question. A claim element reads, a means for winning Nick Tsui's heart. What's the corresponding structure?
Oh my goodness. Yeah, just fun to be around. I think that's gonna be I don't know if that legitimately classifies as a structure, but definitely
corresponding structure.
That's right. Definitely what definitely like, just people who are low key, easygoing, fun to be around. Basically you, Rick. That you would be the corresponding structure.
Thanks, I appreciate that. We've been on for about a half an hour. I won't take up any more of your time today, but I really appreciate you taking the time out and coming to talk to me today. And I thought this was a really interesting conversation. Hopefully the listeners out there learned something from your experience in this area. So thanks for coming on. I'm Rick Bisenius. Thanks for listening to the podcast today.
We want to remind our listeners that the content of this podcast is for educational purposes only and does not necessarily reflect the opinions of Fish and Richardson nor any third party involved, and is not intended to address every court or case situation. Be sure to visit fr.com to listen to all of our past episodes and subscribe to this podcast. You can also follow us on social at Fish Richardson.